Hello, everybody. Today we're going to talk about the brand new purchase agreement that the Ohio Association of Realtors has created to help everybody be on the same one. So we're going to dive right into this. It is going to be a little bit long, but there's a lot of information to cover. So in the very beginning part of the purchase agreement, they have descriptions of what these items mean. So there is a lot of lingo that we use, and we want to make sure that everybody understands what it means. For instance, EMD is earnest money deposit paid by the buyer. On line 15, it says this is an offer. Okay, on line 17, we're putting the property address. That is the complete property address. Line 18 is going to have the parcel ID number found on the county auditor's website. If there are additional parcels to be included in the purchase, you're going to add them all there. Line 19 is further described as one-story ranch, two-story colonial, two-story multifamily, and that short little legal description that you find on the county auditor's website. This ties all this together in a nice little bow, showing legally what the buyer is purchasing. On line 20, you have the purchase price. So that's the price that the buyer wishes to offer on the property. And then we get into the form of payment. They have separated this out. So the first one would be if they're paying cash, they're going to fill out line 22 2A, initial there. If they are paying cash, they have line 23 says how many days before they will give the proof of funds. With Homestar, you need to turn the proof of funds in when you send your offer in, so that should be 0. On line 29, 2B is where they would initial if they're doing financing. And again, we want to make sure that that pre-approval is going over with the offer. On line 31, it talks about the loan application. So this is when they're going to meet their loan officer to continue on with the process and fill out their application and provide their steps. We really want them to meet within 1 to 3 days there, but so if it's left blank, they have up to 7 days to meet with their loan officer, but the sooner the better. You will be marking whether it's conventional, FHA, VA, or USDA. And excuse me. And then down below on line 39 and 40 would be putting where your down payment is. So if they're putting 20% down, you would put that. If they're putting 3.5% down, you would put that, and so on. Line 41 talks about the loan commitment. So we know that's our clear to close. And so on line 42, the buyer shall obtain a loan commitment within. So that's normally 30 days for conventional, 45 days for FHA or VA. If your loan officer says you can close within 25 days, put 25 days there. That's going to be more of an enticement to your seller. Now, they do also mark on here that you want to make sure that you are letting your loan officer and your seller know as soon as you have the clear to close. If your buyer for some reason does get denied, you do need to let them know as soon as possible so that you can sign the mutual release and everybody can move on. If the buyer fails to deliver that notice on line 49, it says the seller can terminate the contract. So make sure that you are communicating as much as you are allowed to with your other side. On line 52, if there's other financing, maybe a hard money loan would go there on line 52. Line 53, buyer to pay $350 commission to Century 21 Homestar. This is non-waivable. All of our clients do have to pay the $350 admin fee. If they do not pay it, it comes out of your commission. Line 54 is if there's a change of funding, you do need to let them know in writing. This is very important. You have to fill out a new purchase agreement addendum and let everyone know if they're changing funding. Okay. Line 57 is the appraisal contingency. This is something that is now hard copied into the purchase agreement. Is the contract contingent upon appraisal or not? All buyers, the contract should be contingent upon the appraisal unless you're paying cash, then there isn't one. So that would be the not. Line 62, Real property closing and sale contingency. This is for your home sale contingency. If the buyer has to sell a home in order to be able to buy this one, you need to let the seller know, and you're going to be putting where the property address is that they need to sell, and if it is already under contract or not. If you're not doing it, then neither one applies. Settlement charges. So this is now put right in here, the help with the closing costs. So this is where the buyer can ask for a dollar amount for closing cost help or a percentage for closing cost help. And all you do is fill in the numbers. Line 73 says they are going to be turning the earnest money in at the very latest 72 hours, which is left blank, or you can put 3 days in there if you like. It is up to you to make sure that your buyer is turning their earnest money in to the title company as soon as possible, but they do have 72 hours to do it. How much the earnest money is on line 74 and who is holding the money, the title company, right? It is very important for you to make sure that you are telling the listing agent that the earnest money has been turned in or that the title company has sent out their notice. If 5 days pass and no one had said anything to the seller, just bear in mind the seller could terminate for lack of buyer doing their due diligence. So let's not get into that situation. This next section also talks about what would happen with earnest money and who would be responsible for getting it or not getting it. But just bear in mind that earnest money is only removed from the trust account with a closed deal, a signed mutual release by all parties stating who can get it, or with a court order from a judge. So you can't just call up and say, hey, this deal's dead, turn my earnest money back over to the buyer. Line 90 talks about fixtures and equipment. So they have gone all out and they've listed a whole lot of items on here to make sure that everybody is aware what is supposed to be included with the home. Also, they have those additional fields for the dishwasher, dryer, range, freezer, range, gas range, refrigerators, washing machines, window draperies, and if there's a wine refrigerator there. And then there's also a line that says something that could be included that's not listed above. And also 165 is if there's something that's going to be excluded from the sale. If there are items that are leased, maybe sometimes they lease a hot water tank, or solar panels are also very popular now, then that item would be here, because sometimes the lease items go with the seller and the buyer's not responsible for that lease. Sometimes they can transfer the lease, so that's something you would have to look into. 175 talks about the residential property disclosure. Of course, we all know that we should have a residential property disclosure for every single property that transfers. The seller is required to fill out and complete the whole entire property disclosure unless they are exempt. So this does state that if they are exempt and can fill out the exemption form, they don't have to fill it out. But if they're not one of those 7 entities on that exemption form, they do need to give your buyer as much knowledge as they have. So 180 is the buyer has gotten it or the buyer has not gotten it. 181, now we get into the inspection section. Of course, we're going to strongly recommend that all buyers get a general home inspection at the very least, so that they know what is going on with the property. You have a choice. You can mark 186 where it says any inspection or test desired by the buyer, or mark them off. I suggest that you at least mark 189 so it is very clear that you want at least the general home inspection. Line 201 now has the language that the buyer shall have the right to perform any additional inspections recommended by the inspector based on the result of the inspection selected above. So you're covered. If you now want to just get the general home inspection, and then if he tells you he sees evidence of wood boring insects or mouse droppings or whatever, you can always go back and add on. Line 205 talks about the inspection period. Of course, we want to get that inspection scheduled as soon as possible, but you do have up to 10 days to get it scheduled. If you're running into a delay because the inspectors just don't have time, please make sure that you are communicating with the listing agent so it doesn't look like you're not doing anything. Line 208, now we're into the request of remedy or termination. The buyer may only terminate this contract for material defects, which include, but not limited to, those defects or conditions which impact health, safety, habitability, use, or value of the property. The buyer may not terminate this contract for non-material conditions such as routine maintenance and cosmetic issues. Very important, guys. You need to read that, because they can't just say, oh, there's going to be too much painting going on here, I'm now don't want this house. It's not a legit reason. Okay. Make sure that you're going over the inspection with your buyer and seeing if they want to remove it, or if they want to remove it subject to conditions below, and list your requests for remedies. Maybe the seller has to hold money in escrow, or maybe they can lower the purchase price if they can't fix the items. But as soon as you put something on that list, you are now changing the contract, so you're back in negotiation. Okay. And the seller can't say no. So if you need help with that, just give us a call. The parties shall have 3 days to reach an agreement about the remedy period. So make sure that you're doing everything timely. If you don't tell the listing agent and the seller after 3 days of getting that inspection report, then they will assume that you are accepting the property the way that it is. Okay, so make sure that you're in communication. All general home inspections need to be done by a licensed inspector. The buyer is going to pay for all those inspections. On line 228, it talks about point of sale inspection. So point of sale is to be done by the seller. The inspection, as far as who is going to remedy the point of sale, that's up for negotiation, and we can talk about that at another time. If your inspector or anyone else damages the house while they're doing these things, the buyer is responsible for the expenses. So make sure that people are not damaging things. Line 232 talks about lead-based paint. So we all know within 1978, if the property was built before that time, then they have to have the lead-based paint disclosure, and also you have to be giving the pamphlet to your buyers and to your sellers about protect your family from lead in the home. This marks on 238 whether they've received it, and also whether they have received the protect your family from lead in the home pamphlet from you. 240 talks about the sex offender registry. That's your Megan's Law. So you can just advise your buyer to do their due diligence online or contact the local sheriff's department if they have any questions about that. Line 250 says seller's cooperation. A seller agrees to make the property available at reasonable hours for access of brokers, buyers, inspectors, appraisers, and so on. The buyer acknowledges that other professionals are not authorized to be present on the property without a real estate licensee unless prior express written authorization is given by the seller. Everyone must be accompanied by an agent, you guys. That's non-negotiable. You just have to do that. It also says on 254 that all utilities shall be remained on until possession to be delivered by the buyer, except utilities that were turned off at the time of showing. However, the seller agrees to have the utilities turned on for inspection, tests, and appraisals. Again, this is important. If the inspector or the appraiser cannot access the water or the gas to see if things are functional, it really hampers everything that's going on. Taxes and assessments. This is the section that talks about how our property taxes are calculated by the municipality. It goes in, it actually is a lot easier to read than the previous purchase agreement. So it's kind of easy for the buyers to understand that. And then the seller and the buyer also acknowledge that the bills received by the buyer after closing could be different because taxes do fluctuate. If the seller knows of anything that's coming up that's not already public knowledge, then they need to note that on 270 there. Then we have the section for short proration method. Very rarely is that going to come into play when you're up here in Northeastern Ohio. The Owners Association. So this is about homeowners associations for condominiums or planned unit developments. And it does say that the seller has to provide the buyer the documents within 7 days if left blank, right? So it's important that your buyer review the homeowners association bylaws and decks, because if they have something that they don't agree with, then they don't want to be in that particular property. So, you know, if they have an RV or a boat, or maybe they have race cars and they want to store them on their property, and the homeowners association will not allow that, they need to know, right? So they do get a review period for that particular thing. Utility charges, homeowners association fees, interest, rentals, and security deposits is next on line 313. And this is where the seller is going to make sure that they are crediting the buyer for these particular things, including but not limited to the security deposits that they have gotten from the tenants. If you are dealing in an investment property and there are tenants that are already living in the house and they're going to stay there, the seller has to provide the security deposit as a credit on the settlement statement so that the buyer will have the money to turn it back over. This is not cash. They're not given cash. This is a credit on the settlement statement. And it also states that they will give all rent rolls and such to the buyer so they can make a good, accurate assumption on whether they want to continue on. Line 326 is the closing services. So who is the title company? Again, whoever is holding the earnest money should be the title company that's closing the deal. This gets into the next section about who pays for what at closing. So they have changed this up a little bit, but the seller is going to be responsible for transfer taxes, homeowners association transfer fees, conveyance fees, deed prep, settlement fees charged to the seller, the cost of removing their deed or mortgage, or any lien or encumbrance they have that goes with that. The seller is going to convey the buyer a marketable title, so that means free and clear. And the title company will do their due diligence to research everything so that we can do so. On line 338, it talks about the seller warrants during their ownership that they haven't conveyed or leased or reserved timber, coal, oil, gas, or other mineral rights, and nor does the seller have the knowledge of any prior transfers or leases. That's also important because if there's mineral rights on that property, maybe there's gas or oil, or even timber, the buyer needs to know that they are also going to be that's all going to be included in the sale, and that someone else isn't going to say, no, I lease this, so therefore now you have to pay me to use it. On line 349, it says make deed to. So who is going to be deeded on the property? Your buyer's name, if the buyer has a spouse, or if there is a mother and a father, or a mother and a son that are buying the property, or whoever, who's going on the deed. 350 talks about title defects. So if for some reason there's a delay in removing defects from the title, this purchase agreement gives them 7 days to resolve the title defects. Our previous purchase agreement gave them 30 days. So if you want to give them a little bit extra time, Mr. Buyer or Miss Buyer, then they can do so, but it's up to you to be asking the buyer what their wishes are. Just remember that you can always sign a purchase agreement extension if things get too muddied with the title and they need extra time. And also that if they don't want to wait, the buyer can sign a mutual release for the sale and have the seller sign it and get the earnest money and get up and move on. Now we talk about the title search and insurance and what that means to the buyer. It is really important that the buyer get title insurance. The most popular title insurance policy is number 1, the Alta Owner's Policy of Title Insurance Standard. In certain instances, you might have a buyer who says, I don't want any insurance. If they're doing a loan, they have no choice because the lender is going to require it. Next section talks about who's paying for that title insurance policy. So normally it's 50-50. The seller pays for part and the buyer pays for part, but the buyer may say they'll pay for the whole entire cost. That does make it a little more enticing to the seller. If the buyer says, no, I want the seller to pay the entire cost, you know, that's just additional things that's going to be deducted from their purchase price. So think about that. Then it talks about this property survey. The buyer does want a property survey or does not want a property survey. Again, that's going to always, it just depends on what's going on with that particular property. Most of the time they don't need a survey, but in certain instances you might need one, right? So 373, Foreign Investment in Real Property Tax Act. So this is talking about if the seller is a foreign person. So if they do not live in the United States, then they are going to be required to hold certain monies because they got to make sure that they're paying everything to the US. This is kind of well, barely applies to anyone, but the language is there because it's happening. So 378 is closing. This contract shall be performed and this transaction shall be closed on the date mutually agreed upon by all parties in writing. So when is the closing date? Line 379, you're going to put the date there. So again, with conventional could be 30 days from the day that you sign. FHA could be 45 and so on. Then it says, when is the transaction considered to have closed? Is it when all the documents have been signed and all the parties in the transaction have been funded, or on the date which the following execution of all necessary documents by the parties and sale proceeds are dispersed to the seller? So when in our eyes do we feel that the transaction is closed? We like when all parties are funded, but your buyer can choose either one. And then it goes on to say, when are they going to receive the keys? So possession on 390. So at the closing, they want the keys, or will they wait until a day after or 2 days after, and so on. So you're going to be filling out whatever the wishes are for the buyer. On 394, important, if the seller maintains possession of the property after closing, it's recommended that the parties enter a post-closing possession addendum, so a rent back. Is it attached or is it not attached? So if you know ahead of time that the seller needs to stay there, then you definitely want to have a rent back so that everybody knows what's supposed to happen after closing. If you don't know, then there's nothing to include. It does state on line 398 that while the seller is in possession, they're going to maintain the property in the same condition or in better condition than what they had it, right? So they're going to also be told that they have to keep the property in broom swept clean condition and remove all debris and personal items not included in the contract when the buyer possesses the home. This is something that's very important. It's now put on the purchase agreement, so you don't have to forget to add that language. Property shall transfer in broom swept clean condition. I can't stress that enough. So many times people get properties that are all jacked up afterwards. The buyer shall have the right for a final verification. So 405 is your final walkthrough. And you want to make sure your final walkthrough is within 1 to 3 days before closing. This does not take the place of the walkthrough addendum for all Homestar agents. You still have to have that walkthrough addendum because on the bottom of it, it's your buyer acknowledging the fact that they've walked through and they're accepting the property. Damage or destruction to the property. So it's really important that if something happens to the property that they attain legal counsel because we are not lawyers. Okay, but it does get into a little bit of a discussion between 410 and 419 about what they can do if there's damage to the property. Line 420 says the buyer's failure to provide one of the notices provided above shall constitute the election of the buyer terminating the contract and because of the damage or destruction to the property. Okay, if the seller fails to provide the notice to the buyer, then the buyer also has the right to get out of the agreement with a signed mutual release and get their earnest money and move on. 424 talks about the home warranty, whether the buyer wants one or doesn't want one, who's paying for it, and how much it is. So that's, again, an optional thing. If the buyer does want one and the seller's not providing one, they certainly can purchase one. It is in their benefit to do so because it covers them within the first year. Ohio Fair Housing Law, so line 427 to 433, it just basically says that we aren't going to discriminate against anyone that can prove they're over the age of 18 and can prove they can pay for the property, we're going to help them buy it, okay? This next section, 434, talks about flood insurance. So this states that all properties can have a flood cert done within the first 10 days after the purchase. It's very important that you get this purchase agreement over to your lender so that they can order the flood certification. All lenders will do that as soon as they get a purchase agreement, so you will be in your time frame. If your buyer is paying cash, there is no one to order the flood cert, so it's going to be up to them whether they want to get one or not. Electronic wire fraud is 438, and this is very important. It's just a reminder to everyone to make sure that you're conscious of this. Buyers agents, beware. There is a lot of scams going out there where you're getting an email from someone who looks like it's the title company saying, hey, I couldn't get this to your buyer. Please forward this for me. Do not do it. Title companies will never contact you and tell you to forward their wire instructions to the buyer. Okay, they're going to contact the buyer directly, and make sure that you're telling your buyers that if they have not received it from the person that they've been normally talking to, then they need to confirm by calling that person and not the number that's listed in the email to confirm these are the accurate wire instructions. It just takes a little minute, guys, but it's very important because you don't want someone wiring off their life savings and then some to someone who's a crook. Line 443, MLS and concessions. Just so all of you know, maybe you're not aware, maybe you are aware, that all closing information has to get given to the MLS so that they can put it in there, including the sale price, what kind of financing it was, and if there were any seller concessions. So that is public knowledge, and it does have to be given to the MLS so that it can be used for comparables, not only for an agent CMA, but also for appraisers to use. Next section talks about how we have to let them know that if they need some advice or assistance on anything that is not in our scope, to make sure they are reaching out to the correct people, whether it's law, tax, insurance, financing, surveying, structural conditions, and so on. Remember to stay within your scope of what you know, and do not act like an expert for something because you may be giving the wrong advice to someone and get sued. Number 452 is indemnification. So this is where the parties acknowledge that the broker is relying on all the information supplied by the seller. Okay, so we can only tell them what we know from the seller, and do not hold us responsible if something is inaccurate. Compliance and dates. Time is of the essence in all the dates that are put in this contract. Everyone must adhere to them. Again, if you need to extend something, please do so with a purchase agreement extension so that you have it in writing by all parties. Disputes. Now, this is a new section that they put in here, but I feel they've done it because they're just getting so many complaints by people, and some of them are just silly and out of their scope and have nothing to do with them. So this tells the buyer and the seller exactly what would happen if they do have a complaint about someone, where to go for that complaint, and what you cannot call them and complain about. So that's 465 exclusions. Line 470 is other terms or conditions. So here is where you could put additional things in case you need to on the purchase agreement. There's your blank lines. What would go here? Buyer is a licensed real estate agent, listing is a licensed real estate agent, or the buyer's agent or listing agent have a financial interest in the property, or they're related to the parties. All of that information must be disclosed so the other party can sign off on it, and here are your lines to do so. The next section talks about how this is an agreement. It is a legal document, and everyone should be doing their due diligence accordingly. That line 483 talks about the signatures. So this means that verbal offers are not a contract. Everything needs to be signed and initialed and dated by both parties in order for it to be legal. Okay, so make sure that everyone knows they have to sign. That's also acceptance, right? So you got to make sure that your other party has accepted the agreement. They've physically gotten it by either printed out, or it's been delivered to them through their dot loop or what have you. 492 is the duration of the offer. So there is your expiration date for this offer for the seller. The next section talks about 494 is all the buyer's information. And line 500 is also new. So we have entity. If they are buying the property as a power of attorney or an executor or LLC or incorporation, you put the name of the entity there. The buyer's signature will be underneath that with the date, and then the buyer's printed name and title if needed. So if it's an LLC, are they a member? Are they the chief operating officer? Who are they? And there's additional signature lines on the right. Note to all of you, whoever our client is, whether it's a seller or a buyer, if they are signing as an entity and not a person, we need the documents sent to the office proving they are allowed to do so. So if it's a LLC and they have more than one person involved in that LLC, we need the operating agreement. If it's power of attorney, we need that, a trustee, and so on. Now we have actions to the sellers. On line 506, it says the seller accepts the buyer's offer. 507, seller rejects the buyer's offer. Or 508, seller counters the buyer's offer. And then if there's a counter offer, there's also a time is of the essence clause. So it's going to be good until so-and-so time, okay? Make sure that when you're putting those time is of the essence clauses in there, so this offer expires on such and such a date. If you've already been told by the listing agent that the seller's not going to review any offers until 5 p.m. on Sunday, don't put your time is of the essence clause at 5 p.m. on Friday, because you're just kicking your buyer out of the running. So you can't force people to act because you're trying to push the timeline up, okay? Again, we have an entity line if the seller is an LLC or a POA or a trustee and so on, who's signing the document and a date for their signature, and then their printed name and their title if applicable. There are additional lines on the right-hand side for another. So the next thing on here that's brand new is 511, release of dower. So this is where the seller's spouse would sign and their printed name would go on the right. Underneath that, you have administrative purposes only. So this is where you as the buyer's agent's name would go, license number, phone number, email address, and brokerage and license number. On the right-hand side, you have the listing agent's information to put there. You will find that on the MLS sheet. And there you have it. There is your complete brand new purchase agreement. Good luck to everyone. And if you have any questions or need help in any way possible, please don't hesitate to reach out to Homestar. Our agents can use the text line, or you can always give us a call. Talk to you soon.